morning once again, everyone. We're now on the record in the matter of the contest of the November 2, 2021 general election for the Old Bridge Township Committee 4th Ward, Mark Rizzoli petitioner. This is docket number MID-L-6893-21. And I have the appearances of counsel for the record, please.
Good morning, Your Honor. W. Timothy House on behalf of petitioner Mark Rizzoli, who's at my left.
Good morning to both.
Good morning.
Good morning, Your Honor. Daniel Antonelli from the law firm of Antonelli Campbell, QC, on behalf of the respondent, Jill DeCaro, who's seated to my right, and across from her is her husband, Dominic.
Good morning to all of you.
Thank you, Your Honor.
Good morning, Your Honor. Deborah A. Allen, Deputy Attorney General, representing the Middlesex County Board of Elections.
Good morning, counsel.
Good morning, Your Honor. Nikki Athanasopoulos, First Deputy County Counsel, appearing on behalf of the Middlesex County Clerk.
And good morning to you as well. Well, welcome to my courtroom and to the wind down of week 93 of the pandemic, but who's counting? It's good to see all of you in person. Just a couple of house cleaning measures. As you see, we've configured the courtroom to facilitate in-person proceedings, and I would prefer that you wear your masks unless you're addressing the court or speaking to the court for your own protection and also for the protection of my staff. But nonetheless, this is the return date of the matter that has been initiated by Mr. Rizzoli as the petitioner. And before we get started, I felt it would be appropriate to kind of set the table as to how we got here in particular today and what this proceeding today will involve. This matter came before the court on today's date on the election contest petition that was filed by and on behalf of the petitioner, Mark Rizzoli, pursuant to NJSA 19:29-4, and which was filed on December 2nd, 2021, which was accompanied by this court's initial case management and pretrial order that was entered on December 2nd, 2021, and the court's supplemental order that had been entered on December 10th of 2021. Mr. Rizzoli was the nominee of the Republican Party for Old Bridge Township Committee 4th Ward, having won the Republican Party nomination in the June 2021 primary election, and who sought re-election to that seat in the 2021 general election as the incumbent seat holder for the 4th Ward. The respondent, Jill DeCaro, was the nominee of the Democrat Party for Old Bridge Township Committee 4th Ward, having won the Democrat Party nomination in the June 2021 primary election, and was the challenger for the 4th Ward committee seat held by Mr. Rizzoli. Mr. Rizzoli's original petition in this matter contained 3 counts. In count 1, entitled Legal Votes Rejected, he alleges that the 33 voters who live in the 4th Ward who were provided ballots to vote in the 2nd Ward were denied their right to vote in the 4th Ward Township Committee election, and therefore all voters who were denied their right to vote in the 4th Ward Township Committee election were legal votes wrongfully rejected pursuant to NJSA 19:29-1E. And that statute reference provides a remedy which is sought here by the petitioner, namely the nullification of the 4th Ward election results and the scheduling of the special election anew. In count 2, which was entitled Illegal Votes Accepted, he alleged that 15 emergency ballots were accepted for the 4th Ward Township Committee seat, contending the use of emergency ballots on November 2nd, 2021 was not legal, and that instead provisional ballots subject to verification after the election by the Board of Elections should have been used, noting further that there were, quote, material procedural defects in the use of the emergency ballots. And according to the allegations made, because of the use of emergency ballots was not legal, in other words, since district board workers are not able to verify the voters using the new electronic poll books due to Wi-Fi connectivity problems experienced at the polling places on election day, that NJSA 19:29-1E also provides authority for the petitioner as a candidate to contest the election when, quote, illegal votes have been received or legal votes rejected at the polls sufficient to change the result. And in this regard, it was specifically alleged that the emergency ballot vote totals tallied reflected that Mr. Carroll, the Democrat nominee, had 12 of those votes, and Mr. Rizzoli had 3 of them. And finally, now, in the original petition, in count 3, which is entitled "Illegal Vote by Mail Ballots Accepted," it was alleged that numerous vote by mail ballots were illegally accepted with voter addresses at 100 Ticetown Road in Oak Ridge Township, which is the address of a high-density senior citizen housing complex. And it was contended that the illegally accepted vote by mail ballots were riddled with irregularities, such as, among other things, the vote by mail ballots were accepted without signatures. Ballots had names handwritten in the signatures. File being accepted, voters were assisted with their vote by mail ballots, but the assister fields weren't completed as required, and voters were being assisted by a candidate contrary to New Jersey election law. Now, I pause to note that the 2021 general election was conducted to a major change to New Jersey election law, which, as it turned out, as the judge who handles election law matters in this county, this was the third major change in 4 years, and in the face of the previously declared state of emergency occasioned by the onset of the COVID-19 pandemic, which remained ongoing during the 2021 election and remains ongoing. And for the first time in New Jersey's history, a 9-day period of early voting was authorized in selected municipalities in each county from October 23rd to 21, which is the 10th day prior to the election, through October 31st of 2020, which was the second day prior to the scheduled general election on November 2nd. And during this period, early voting and voting on election day was conducted using new electronic polling books and voting machines at designated polling locations and new designated early voting polling locations in each municipality. And specifically, in-person early voting and voting in person on election day was conducted utilizing the electronic poll books, which were connected to the statewide registration system using Wi-Fi connections in each polling place. And the new voting system was implemented as a result of the Early Voting Rights Act that was adopted by the legislature and signed by the governor into law back in April of this year, but were implemented for the 2021 general election, and it appears without the benefit or experience of any pre-election or pilot program. Nonetheless, this court entered its order and supplemental orders providing for case management and setting this date down as the date that could be accommodated pursuant to the election law statute, in that this is an election contest, and under the statute, the court is obligated to set the matter down for a trial within 30 days of the filing of the election contest petition, which in this case was timely filed, and no sooner than 15 days before after the filing of the petition. So hence this date was selected, and the statute does provide for flexibility for an adjournment of the trial if necessary for a period of no more than 30 days, but that's not before us at the moment. Now, in my pretrial orders, I allowed the parties to engage in accelerated discovery, and as a consequence of that, on December 17th, 2021, the petitioner, Mr. Rizzoli, filed an amended petition, and particularly count 1 was amended to specifically identify and name 17 voters who resided on the even-numbered side of Cymbeline Drive, who it's alleged were incorrectly voted in Ward 2 at District 4, and 15 of whom lived in Ward 4 and District 3 were provided ballots to vote in Ward 2, District 4, and thus it's alleged were wrongfully denied the right to vote in the Oak Ridge Township, 4th Ward Township Committee election. Count 3 was also amended to allege that 43 vote-by-mail ballots were illegally accepted at voter addresses at the Senior Citizen Complex at 100 Ticetown Road. Now, on December 15th, 2021, prior to the exchange of discovery, the respondent, Mr. Caro, moved to dismiss the original verified petition pursuant to Rule 4:6-2E. And in that motion, she claimed that count 1 of the original petition contained a fatal flaw, and that it failed to identify by name any of the 33 registered voters who the petitioner claimed were denied their right to vote in the general election for the 4th Ward seat because they were provided ballots to vote in the 2nd Ward but were eligible to vote in the 4th Ward. It was also argued, and for reasons I won't belabor here, but the motion to dismiss also argued against and sought a dismissal of counts 2 and counts 3. And finally, simultaneous with the filing of his amended petition on December 17th, 2021, the petitioner filed a motion for partial summary judgment, actually a summary judgment on count 1 concerning and alleging that there being no genuine issue of material fact that would preclude him from the entry of judgment as a matter of law due to the 17 legal votes that were rejected in light of what was the certified result of an 11-vote margin in favor of Mr. Caro. The clerk had certified the results, which provoked this contest, showing that Mr. Caro had received 1,554 votes and Mr. Rizzoli received 1,543 votes, which is the 11-vote difference. Upon the filing of the motion for summary judgment and the amended petition, and as a consequence of continuing accelerated discovery, additional motions for summary judgment, cross motions for summary judgment were filed on behalf of Mr. Caro, and as a consequence of that, at the party's request, the court conducted a updated status conference this past Monday, December 20th, and let the record reflect that in that Zoom conference with all counsel, it was the collective belief of the parties that in lieu of having witnesses appear for a trial, that the court first consider the cross motions for summary judgment in this matter, and in light of the narrowed issues that have been joined. And the court acceded to that. And with that came the filing of a cross motion for summary judgment, also on behalf of Mr. Caro. And on December 21st, yesterday, the court was in receipt of Mr. Howe's letter on behalf of the petitioner, in which it was indicated that Mr. Rizzoli would be seeking a voluntary dismissal pursuant to Rule 4:37-1B of counts 2 and counts 3. And I guess that sets the table as succinctly as I can lay it out for you, counsel. And I guess the first order of business I'd like to address is the petitioner's request for a voluntary dismissal of under Rule 4:37-1B. Mr. Howe?
Did want to take off my mask a second too. Thank you, Judge. So we got our initial discovery. We've assessed what's in that discovery, and what we see is on count 2, there would be a need, if we were going to proceed on count 2, a need for more additional discovery, more requests, probably a lot of testimony. What we allege in count 2 is backed up by observations of our polling place challengers and whatnot. In count 3, there was nothing inconsistent in the discovery with our allegations, which likewise come from challengers, likewise come from people who've done some asking around. However, given the drive to get this case resolved in a timely manner consistent with Title 19, and not end up with a case that goes on a year into the term, which I've seen from a distance, after conferring with Mr. Rizzoli, we decided to focus on count 1. Count 1, which after discovery, we saw where the numbers stood. So in the interest of judicial economy, we would like to see that dismissed. The letter was sent out yesterday morning about 11 and change. Judge, just as for the record, for about 30% of the time I have a problem uploading from this computer onto eCourts, and this computer is much newer than eCourts. So I apologize that I just sent the letter, but I wanted to get it into counsel's hand and your Honor's hands as soon as possible.
All right. Mr. Antonelli, any objection?
Judge, the respondent does not object to this.
Okay. I will grant the application seeking on behalf of the petitioner, Mr. Rizzoli, a voluntary dismissal of counts 2 and count 3 of the amended petition, and that would, I'll enter an order to that effect with prejudice. Okay.
Is Your Honor instructing me to submit a form of...
No, well, I'll deal with that when we get towards the end of things today. I did want to note, though, for the record, also, to round out the record in the discussion I had with counsel in our status conference on Monday, that in believing the collective sense of counsel for all the interested parties here in proceeding in this fashion without having a trial with witnesses subpoenaed here, which certainly the statute contemplates, because of the narrowing of the issues, I did indicate that if and as in ruling upon the cross motions for summary judgment, I determined the need for a trial, that a trial would have to be conducted after the first of the year and after the reorganization meeting on January 4th, which would mean that in the event I determined the need for a trial, I presented 2 dates for the parties in January 14th or January 18th, by which to conduct the trial if and as it's needed. That would mean that we'd still be within the 30-day one-time adjournment allotted under the statute of the trial date, given the circumstances, but I wanted to give the parties the heads up on that, and that would mean that if it came to that eventuality, I would have to enter an order that would stay the taking of office in the 4th Ward Township Committee seat pending the outcome of that trial. But we're not there yet. We've attempted to narrow the issues, as Mr. House says, and with the benefit of the effort and the most appreciated effort by this court of all counsel involved here to narrow the issues to what is being argued here today. So I will enter an order and make provision for a voluntary dismissal of counts 2 and counts 3, which now leaves me with the respondents' pending motion to dismiss. And in light of the dismissal of counts 2 and 3 and the amended petition, Mr. Antonelli, doesn't that render your motion to dismiss moot on count 1?
Thank you, Your Honor. May it please the court. With all due respect, it does not. Judge, to the extent that our motion to dismiss counts 1, 2, and 3, to the extent we consented to counts 2 and 3 being dismissed, we don't believe changes the merits of the motion as filed as to count 1. I know we're moving quickly because we're required to do so, and while normally I would dispense with rehashing, if you will, the arguments in my brief, I would like to take a few minutes to create that record, because I think it's important. So, Judge, I do want to start off with Mr. Howe's letter of December 21st, 2021, and I believe what's telling about that letter, Judge, is that in paragraph 2 of that letter, Mr. Howe indicates the first round of discovery did not provide petitioner with any sufficient information to proceed on count 2. And Judge, I think that's telling as it relates to count 1 as well. Judge, the statute 19:29-2 doesn't allow for a petition to be filed and in hopes that later produced discovery will give and provide the petitioner with the required information under the statute. In this particular case, Judge, upon filing of the petition, its respondent's argument and position that it was fatal, it was defective upon filing. And with all due respect, this court is bound by the case law to reject and dismiss the motion to dismiss. It's not permitted to be revived because it was defective upon filing. The statute says when the reception of illegal, or in this case the rejection of legal voters, is alleged as a cause of contest, the names of the persons who so voted. So the first part of that statute requires the names to be set forth.
If known.
I'm going to get there.
Okay.
So that's the first part. Second part, the election district where they voted or for the vote shall be set forth in the petition if known. Judge, in this case, okay, there is not one disclosure of one name in the petition. And we believe for that reason the petition is fatal. when you look at in-rate contest, general election for the mayor of Township of Parsippany Troy Hills, which, as your honor is aware, is a Supreme Court case. And in that case, Judge, a motion to dismiss was filed and granted. It went to the appellate division, reversed, and then it was affirmed in the Supreme Court. And Judge, in that case, you know, the losing mayoral candidate's petition seeking to contest the election on the basis that illegal votes had been received or illegal votes had been counted was sufficient to withstand a motion to dismiss for failure to state a claim. Petition listed the names and election districts of the voters whose votes were being challenged. It also included a code reference to the basis for the challenge to each of the votes and described the irregularities with the absentee ballot. So Judge, we have Supreme Court precedent that requires names to be listed. In addition to that, Judge, the Supreme Court took the time to reference the petition of Clee case at 119 NJL 310, which is a case, Judge, from 1938, the year that my father was born. And in that case, Judge, I'm going to just quote a few sections which I think are highly relevant to respond to this motion here. In that case, when the reception of illegal voters or the rejection of legal voters is alleged as a cause of contest, the names of the persons who so voted or whose votes were rejected with the election district where they voted or offered to vote shall be set forth in the petition if known. In that action, Judge, the contestant did not know the names of such persons. But when you read further along in the opinion, Your Honor, I believe what's important here is that Your Honor went right to the issue, if known. And I don't believe that qualification, if known, addresses names of the petitioners in the petition. Those names need to be set forth, and I don't believe the if known language allows, as in this case, a petition to be filed that does not disclose the name of one single voter and allow it to be amended upon the receipt of discovery.
You don't dispute that the street addresses of those voters was in the original petition, do you?
Judge, we don't dispute that, but we don't believe that satisfies the statute.
And there's nothing in the election statute that overrides Rule 4:9-1 that permits an amendment of the pleading, is there?
Not necessarily, however, why I will say, Judge, when you look at the petition here, this is not subject to liberal pleading requirements, not subject to the normal rules. And in fact, it's the inverse here. This pleading, this petition needs to have more specificity, which it does not.
Well, that's not what Rule 4:6-2E that you're moving under contemplates.
Well, Judge, our position is that
The standard of review of a 462E motion is pretty clear, which is established in the Supreme Court's decision in Printing More Morristown versus Sharp Electronics, 116 NJ 739, 1989. Because a motion is made under Rule 4:6-2E, the factual background is gleaned from, in this case, the petitioner's petition and accepted as true for purposes of analyzing whether to dismiss it. And as Printing More Morristown instructs, and in reviewing a motion to dismiss for failure to state a claim under 462E, the standard of review is whether the, in this case, the petition fails to articulate a legal basis entitle the plaintiff to relief. And it requires the court to, quote, search the complaint in depth with liberality to ascertain whether the fundament of a cause of action may be gleaned, even from an obscure statement of a claim, opportunity being given to amend as necessary, close quote. Those aren't my words. That's the Supreme Court.
And I understand that, Judge, but I still believe that the application is appropriate, notwithstanding the language quoted in Your Honor in that case, to the extent that, yes, Your Honor is to look at the petition, is to search it, and accept as true what's in there, but the statute that controls resolution of whether or not it's sufficient is the one that we quoted in the case law.
Which has been amended to identify the voters by name.
There's no dispute that the petitioner filed an amended petition. However, our position is that it was fatal upon filing and not subject to an amendment, because you can't amend something that wasn't sufficient in the first place.
Well, sure you can, counsel. That's why we have Rule 4:9-1, and that's why the standard contemplates, even from an obscure statement being made, amendments, given the litigant the opportunity to amend is necessary. Given the circumstances, it's pretty clear to the court that, given the accelerated nature in which these kinds of proceedings take place, have to meet the statutory deadline to file the petition, don't have an opportunity to get the information, you get the information, and I gave the parties accelerated discovery, and the information was revealed, and it was promptly amended to satisfy the requirements of the statute.
Judge, am I continue with
You
my
may.
argument, please?
Yeah.
Thank you. So, Judge, when we look at the Cleat case as well, they had the bare statement that 55,000 votes were illegally received. No effort was made to identify a single one of such voters out of the 8 municipalities. So whether it's 55,000 votes, or in this case, petitioner referenced 33 registered voters, we believe the result is the same. Judge, when I also look at bear with me for 1 second, Your Honor. Going back to the Parsippany Hills case, Judge, a Supreme Court case, I'm just going to quote, unlike the broad and vague assertions described in Clee, which I had just referenced for Your Honor, and the equally broad attack on the election in Murphy, which is cited in our brief, that petition, that meaning the petition in the Parsippany case sufficed. It listed the names and election districts of the voters whose votes were being challenged. Again, Judge, our position's the same. We believe the petition was deficient upon filing. It's not subject to amendment, and we believe, for the reasons cited in our brief, as well as the opportunity to argue before you, that petitioner respondent's motion to dismiss should be granted. Thank you.
Okay, very well. Thank you, Mr. Antonelli. Mr. Howard?
Just one thing, Judge. The original filing, the original scheduling order of this court, which was achieved after our first conference, I believe, provides for a deadline for the amendment. I think it was pretty clear why that deadline was there and why it was after the discovery response deadline. The Board of Elections met maybe even a couple hours early their discovery deadline. It was pretty clear that why it was there. As far as the rest of it, I will submit, and you know, I'd sort of like to move on if we could when Your Honor instructs to the merits of the subject judgment motions.
Yeah, all right. Well, listen, procedurally, the motion's before the court, and I've heard Mr. Antonelli's argument. And of course, I respect it and his argument. But again, let me rule on that aspect of the motion. What's left is a motion to dismiss under 462E the first count of the amended petition. And the argument made is that the original petition failed to disclose the identity of the voters, albeit it did identify their addresses, and simultaneously with the filing of the original petition, this court entered its initial case management pretrial order that provided for the parties to engage in accelerated discovery, which occurred. And as a consequence of that, the petition was amended to provide for the identification of each of the 17 voters who were implicated in this matter. Now, again, under Rule 462E, as I've indicated, because the application was made to dismiss that count under that rule, again, the factual background is gleaned from the petition as amended and is accepted as true for purposes of analyzing whether to dismiss the petition. And I've quoted to the Supreme Court's decision in Printing More at Morristown, which is the standard. Generally speaking, if a generous reading of the allegations merely suggests a cause of action, the complaint, or in this case, the petition, will withstand the motion to dismiss. Again, not my words, that's of our Supreme Court, FG versus McDonald, 150 NJ 550, 556 in 1997. decision of the court, and a complaint or petition in this case should not be dismissed under 4:6-2E, where a cause of action is suggested by the facts, and a theory of actionability may be articulated by an amendment to the complaint. It comes from Pressler and Vernero, current New Jersey Court Rules annotated, comment 4.11 to Rule 4:6-2, citing to the Supreme Court's decision in Printing Warrant Morristown. And I think it's important that in Printing Warrant Morristown, the Supreme Court was clear in its instructions to the trial courts. And I'm quoting from its decision, quote, "We approach our review of, in that case, the judgment below mindful of the test for determining the adequacy of a pleading, whether a cause of action is suggested by the facts. And in reviewing a complaint or a petition dismissed under 4:6-2E, the inquiry in examining the legal sufficiency turns on the facts alleged on the face. And as the court instructed, at this particular preliminary stage of the litigation, the court's not concerned with the ability of the plaintiffs to prove the allegation contained in the petition. It's sufficient that, and it also goes on to say that for purposes of analysis, the petitioner in this case would be entitled to every reasonable inference of fact. And as the Supreme Court concluded in Printing Warrant Morristown, and quoting again, this is at 116 NJ, 772, 172. The importance of today's decision lies not so much in its explication of the principles involved in that case, but as in its signal to trial courts to approach with great caution applications for dismissal under 4:6-2E for failure of a complaint to state a claim on which relief may be granted. We have sought to make clear that such motions, almost always brought at the earliest stage of the litigation, should be granted only in the rarest of instances. And if a complaint must be dismissed after it has been accorded the kind of meticulous and indulgent examination counsel in his opinion, then barring any other impediment such as a statute of limitations, the dismissal should be without prejudice to a plaintiff's filing of an amended complaint. Well, that's occurred here. The amended petition was filed after the court authorized accelerated discovery began and amended to satisfy the requirements of the identification of the voters. And as the case law instructs, it's not the petitioner's burden to prove who they voted for or who they might have voted for. It's just sufficient that they're identified, and that has been done. So for these reasons, the application of the respondent Caro to dismiss count 1 of the amended petition of the petitioner is denied. Let's move on now to the motions for summary judgment, which has really brought us here today. And in that regard, we begin first with the petitioner's motion for summary judgment, and in that respect, Mr. Howell, I'll hear you.
Thank you, Judge. In a state of 9.4 million people that we now know from the decennial census, 21 counties, there's always one or two cases, one or two elections, that is, who come to this point. Courts I know are shouldn't be readily willing to intrude into election matters, but there are always one or two that get from New Jersey every year that get to a point where they cry out for a judicial answer to a problem with the election. This case, we have a map which I received in discovery, which was Exhibit B. In order to clarify that map, zoomed in on it a little bit to the best of my technical ability to show the shape of the street, to show that that was indeed Cymbeline Avenue with the ward line drawn down the middle of the avenue, road. We submitted further screenshots showing the even-numbered homes of people who voted to show that they were indeed on the north and east side of Cymbeline Avenue. So those exhibits all to show, since the original exhibit didn't show exactly even and odd, and indeed didn't have the name Cymbeline on it, wanted to clarify that the even number side, which contains in our original calculation 33 voters.
Now, let me just ask you a question about the map. Is there any dispute that the boundary line between the 2nd and 4th wards is Cymbeline Drive?
I not only do I dispute it, I'm asserting that.
Okay, and the map that you're alluding to, Exhibit B, delineates the boundary line that is the ward that has not been revised or adjusted by any ward commission.
Yes, Your Honor. In my understanding, and that's why I included the original discovery letter asking for the map adopted by the ward commission after the 2010 decennial census to show, to sort of connect the dots there as to what that map wasn't just something that was pulled off of a website somewhere. So this case is almost, in principle, is almost identical to the Parker case, which was decided earlier this year, which I was trial counsel on. In the Parker case, there were, Atlantic County has freeholder districts, sorry, well, they were called freeholder districts then, commissioner districts, Your Honor. And in that case, ballots were sent to people, to voters within the district that Andrew Parker was running in that did not contain that contest. And then also, parenthetically, there was ballots sent to another district that did contain that contest. In that case, the mistake was made by the Atlantic County clerk, and the free market of ideas and elections is taking care of that situation. In this case, we make no allegations that the Middlesex County clerk did anything wrong, and I don't think that, I think that distinguishing it on the fact that, well, Parker, it was the county clerk messed up, but here it wasn't. It's not about who made the mistake, it's the fact that the mistake was made. The fact is that the map shows where the even numbered side of symbol line is supposed to be. Those folks are in the statewide voter registration system, according to everything I've seen, in the second ward, and it's second ward district 4. They should have been in fourth ward district 3. So much like the voters in the Parker case last year, they were denied the right to vote on their ward representative. The fact that they're in the statewide voter, so the statewide voter registration system is maintained in certain ways. The clerk gets to rely on it. But the fact that it's wrong doesn't legally change the situation or the analysis. The fact that it's wrong, it clearly shows that the Middlesex County Clerk's Office did not themselves make the mistake. It's not an arbitrary line, Judge. The ward lines are drawn, and this is where I need to refer to, the ward lines are drawn by a commission comprised of the election board members and the municipal clerk. That's established by 40:44-11. The baseline standard for drawing the lines is in NJSA 19:40-44, and the report of the boundaries is published pursuant to 40:44-16. And the whole process is governed by certain standards which we don't need to go heavily into. It's not just a line that we can say, well, it's a line, you know, it could be arbitrary like a border, you know, like where does Central Jersey end and North Jersey begin? No, it was set because of numbers of voters, because of principles of one person, one vote, and not, et cetera. I think, you know, I could anticipate an argument that, well, they're in the statewide voter registration system in Ward 2, District 4, so therefore that's where they belong. And generally, there are plenty of times where Mr. Antonelli or I might be in a courtroom, in a petition challenge, or some other legal proceeding where the statewide voter registration system is regarded as controlling on the facts. However, here we have a pretty clear indication that the facts in the statewide voter registration system are wrong. It's not 2 tablets carried down from Mount Horeb. by Moses. It's something that we're going to rely on, and the county clerk gets to rely on, the election board gets to rely on, but in this circumstance, we get to look further. And looking further, we see that the entries that were relied on by the Middlesex County Clerk and the Middlesex County Board of Elections were wrong. I don't think the fact that it was in there, that these voters were in the statewide voter registration system, in the wrong ward, controls this factually. So it reminds me of back when I was a young teenager and we had the old passbook savings accounts before everything was digital. I made a deposit probably after a birthday or something, because how else does a 12-year-old get money? I know, they could work. There was a mistake in the passbook, and like all of a sudden it was like $700 where there should have been 26. Was that my money because of the mistake in the passbook? No. I can anticipate arguments that say, well, but they may have voted already here before. Does that matter? No, they're supposed to be in the 4th Ward, 3rd District. You know, those elections, including one that involved Mr. Rizzoli, the time to argue over whether those voters were in the wrong place passed a long time ago, from 2017 and 2013. They're supposed to be there. The only time it matters is in a ward council race. The rest of the time they're voting. The rest of the time they're voting on at large or Middlesex County commissioner or constitutional officer. So, with the Parker case and Parker, the Parker court, Judge Mola wrote the opinion, rested very heavily on the Grace Sadler case. These are votes then that were, these were legal votes that were rejected. In the Parker case, we heard argument that, well, that's meant the polling place. These were legal votes that were rejected, just like in Parker. In my brief, although I did see one typo this morning, it's always wonderful to see a substantive typo in your own brief on the way to the courthouse. Very comforting. After we got discovered, we saw that 17 of these folks had voted. The county clerk's certification, which I think put the number at something different. I believe they put it at 14. Either number exceeds 11. In fact, if this were a case would go to trial, for reasons we don't need to argue about today yet, under the Parker decision, everybody who got a ballot that was wrong, or everybody who was directed to the wrong polling place is a legal vote rejected under the Parker decision. For purposes of a summary judgment motion, I want to make it as narrow as possible so there'd be less wiggle room under the standards for summary judgment. There's nothing to indicate in this case that that these voters were at fault in any way. A voter who makes a mistake on a ballot or doesn't follow directions on a ballot, whose legal vote is rejected, those votes don't always get cured in an election contest. The indication is that the flaw was within the system and not within the voter. So these voters should have been able to vote in the 4th Ward. So when we get to this point, it looks to me like that we have at least 14 voters. If we take the county clerk's number who actually ballots were accepted, I would say there's 17. I could argue at trial that there were 33. Then these were legal votes that were rejected. We don't have to prove voter intent here. The language in going back to Grace Sadler really is very instructive, that when it's legal votes rejected, there's absolutely no burden to prove the intent of the voters, unlike illegal votes accepted, where we have to bring the voter in. If the court determines that it's a legal vote, who would you vote for? And that's not an enjoyable number for anybody who appreciates living in a constitutional republic. So we don't have to prove who they would have voted for. We just have to prove that there were enough qualified voters who denied the right to cast votes to affect the outcome of the election. That goes, through the Parker decision. It goes back to the Gray Sadler decision on which Parker relied, and the Maple Shade decision on which Gray Sadler relied. It's the standard here. It's how many, what was the margin, does that exceed the margin? In the Parker case, a lot of arguments were made about the number. The fact is, the number of legal votes rejected by those ballots going into, those wrong ballots going into Mr. Parker's freeholder commissioner district. And that was the end of the, case. That case was stipulated, 7 pages of stipulations. And the court ruled in our favor at the trial court, and the appellate division upheld it in a published decision. So those are the decisions that control. There's enough here on which to grant summary judgment. We have my response clearly would be any factual dispute. Well, is it a genuine issue? I don't think there's anything that's been raised so far that's a genuine issue of material fact. Certainly there's denials of the, as is the respondent's right to different bullet points in the statement of material facts, but are those really genuine issues? That's why I addressed the issues with the statewide voter registration system. That seems to be the basis of the factual dispute. They're supposed to be in the 4th Ward, 3rd District. The fact that the statewide voter registration system put them in the 2nd Ward, 4th District does not create that issue under the current facts. So, I don't think we need to go to trial on this. There's enough here. The law is very good. The law is very clear. We ask the trial give us summary judgment on that.
Thank you. Anything else?
Thank you, Your Honor. Your Honor, with regard to, again, I won't belabor the court. I think it's been pretty well briefed on short notice. But I would like to point out a few things. The Parker case that counsel is relying upon, I don't think it applies here. In the Parker case, there was no dispute that the county clerk sent a defective ballot that did not contain the names of the 2 individuals running for commissioner. To the extent that we're now focused on a legal vote rejected, I would agree with counsel, voter intent is not before the court. So I agree as to the standard. But Judge, in this particular case, what's different from the Parker case, factually, is here we have a state voter registration system, which has been set forth in our brief, which places the 17, the 14, the 33 registered voters on Cymbeline Avenue in Ward 2. That is the official registry, that's the official database, and that is what the county clerk relies upon. And don't believe we had the benefit of the certification of the county clerk prior to filing our brief, but it's pretty clear once Your Honor reads through the certification that the county clerk has to follow Title 19, do certain things by certain dates, and one of the things that she is not able to do is to make any changes to the state voter registration system. So,
Nor can she change the boundary lines of the ward.
well, that presumes, Judge, in the first place that in fact they were changed, but I'll get to that issue.
Okay, well, before you do, let me pose the same question to you that I posed to Mr. Howe. Is there any dispute that the boundary line between the 4th Ward and the 2nd Ward was the center line of Cymbeline Drive.
Yes.
There is a dispute.
I don't read the map the way council reads it. I don't know that it actually says that. There is a line on Cymbeline Avenue. I don't necessarily believe that the map definitively says that the even number residents are in Ward 2 and the odd number are in Ward 4. I don't believe it stands for what's being presented, at least on this record. And frankly, Your Honor, it's respondent's position that we're not even relying upon or focused on the map here. We are focused on the state voter registration system, which the legislature created by law many, many years ago to create one database, one registry, and obviously county commissioners can make changes to the system. But in that regard, Judge, I don't know why, I don't know how. If you accept petitioner's argument as true that they should have been in Ward 4, but it's our position that the record evidence and the benefit of discovery that we have and the review of it would indicate that they received the proper ballot and these individuals voted in the 2nd Ward. In addition to that, Judge, I find that the record evidence, which again is put before the court in our cross motion, indicates that in 2020 and 2019, these universe of registered voters were also in the 2nd Ward.
How would that be material if the statewide voter registration system is wrong?
Judge, I don't believe on this record there's any evidence that says it was wrong. And I think in this scenario, we're talking about an election challenge, and the petitioner has the burden, not the respondent, to show that in fact the 17 voters, 14 or 33 registered voters, were in the wrong ward. And I don't believe he's met that burden, Your Honor, on the record that's currently before the court. And I do believe there's, at a minimum, I believe the state voter registration system should control resolution of the issue. But if Your Honor is inclined to disagree with that, I believe there is a disputed issue of fact as to the 33 or 17 or 14 voters at issue and what ward they're actually in. So I didn't argue that in an alternative, but based upon Your Honor's question, I would think that at a minimum there is a disputed issue of fact. I don't think what Mr. Howes has presented by way of record evidence shows that there's not.
Well, the map discloses the line, right?
Judge,
And that line was created by a ward commission and has not been altered until the next decennium.
Judge, I would beg to
So-
differ. I mean, well, there is, and it's hard to read, but in the bottom right corner of the map that was produced by the Attorney General says it was revised in November of 2019. We don't have any information other than that's what it says. But again,
But
Judge,
as revised in 2019, it shows the boundary line between the 2nd and 4th wards as Cymbeline Drive.
Judge, I'm not disputing that the map has a line going down Cymbeline Avenue. What I'm disputing is the record evidence that's before the court, which shows that the even number are in fact residents of or registered voters of the 4th Ward. And I believe, again, when you go back to the state voter registration system, which we believe controls the resolution of the issue, the county clerk had no choice but to provide a Ward 2 ballot because that's what the system said. And we believe that controls the issue, and that's also the reason why we believe Parker is distinguishable. There was no error, and council conceded there was no error by the county clerk here. And if there was an error, again, Judge, on this record and the record evidence before Your Honor, there is disputed issues in fact as to the even number of registered voters. And we believe for that reason, Judge, if you're inclined to deny our cross motion for summary judgment, we would ask the same that be done for petitioner.
Mr. Howe?
Judge. Just one point.
And I'm sorry to interrupt you. It would be a great help and benefit. Mr. Antonelli, you appear to have a color copy of the map.
Yes, Judge, actually, I made several copies.
Okay, good.
In the event Your Honor asked for them.
Oh, there you go. Thank you for your foresight. It would be of great help to me to have that. And what I'd like to do is, there's no dispute, I'd like to mark that as an exhibit.
No, there's no dispute because it appears to be, well,
Judge, perhaps I could show counsel what I have
Yeah.
and give him a copy. So Judge, just so the record's clear, the map that was produced by the Attorney General is in color printed, but of course it's very, very small and hard to read. So what we did was we also blew up the area at issue here, which was from the original map that's hard to read because the print's so small.
No, I appreciate that very much.
I just want to take a quick look. It looks like,
You can have that.
yeah, it does look like the same.
I'll represent to the court that that is what was given to us in discovery by the Deputy Attorney General.
It absolutely was, and I would never have doubted Mr. Antonelli's representation in the first place.
Okay, so what I'd like to do with counsel's representation, since I only had the benefit of the black and white copies of Littered Equals.
We have a little more sophisticated
Yes,
computer system in our office.
It's very much appreciated. But what I'd like to do is, I would mark as, I'll call it Court's Exhibit 1, which would be the colorized copy of the map that had been supplied by the Attorney General, correct?
That is correct.
Okay, Dorian, you're going to mark this as Court's Exhibit 1. And just on this exhibit, just to note that there is some yellow highlighting that focuses in on the area in question.
And Judge, for the record, I actually did that.
Yeah, okay, and thank you. I
did
expected that.
The yellow just to kind of.
Well, it helps me train my eye on what I'm looking at. And then the second document, which will mark as Court's Exhibit 2, is just counsel's blow-up of the area that's encircled on the yellow highlighting on the first exhibit, correct?
That is correct.
Okay, so we'll mark that as Court's Exhibit 2. And for purposes of this record, I will deem them admitted into evidence without objection.
Well, without objection, or
No objection.
essentially what I submitted.
Yes.
Judge.
Okay.
Although,
Maureen, that's two, this is one.
Oh.
Yeah, these marked it. Okay. Okay, thank you. Just let the record reflect that I've had my court clerk mark the colorized map titled Old Bridge Township, Middlesex County, Election Boards and Districts. The council had been provided by the Attorney General's office as Court's Exhibit 1, which bears the yellow highlighting encircled by Mr. Antonelli for the court's benefit, which is appreciated. Similarly, I've marked as Court's Exhibit 2, Mr. Antonelli's blow-up of the area in question that's encircled by the yellow highlighting, and also as a colorized version of that. And they'd be deemed admitted into evidence for the purpose of this proceeding. Okay.
Judge, if I may, just
You
for
may.
clarification, on Court Exhibit 2, it's, at least the copy I'm looking at, it's a blow-up of the encircled area, but there is no yellow highlight
Correct.
that I inserted on Court 1.
There are yellow lines, but those are original on the
Correct, those were not mine.
showing, appear to be bound.
So Court Exhibit 2 is a blown-up version
Yes.
of the area at issue with no markings whatsoever by myself.
Okay, thank you. And looking at Court's Exhibit 2, though, the blow-up, there isn't any identification of, at least from what I can see, where Cymbeline Drive is there?
That's why I submitted the other exhibits to clarify that. Because it's not, I would submit that not written even in the one-point type of this map, the Cymbeline. That's why I submitted additional maps to show that, you know, Cymbeline runs between Priest Hill, Press Hill Road. It starts there and goes sort of west and north. And then the other exhibit to show that the even numbered side is on the east and north side of Cymbeline. But I 100% agree that it's not there.
Yeah.
Even, I don't even know if there must have been an original. I'm going through this process in one of my townships right now. I know that the map gets bigger than this, and with mine, but I would agree that that's there. One other housekeeping item, Judge. So the county clerks, the certification submitted on the county, on behalf of the county clerk, has been referred to. It is in e-courts. Do we need to mark that, Your Honor, since we've referred to it?
We don't necessarily have to mark it. It is an exhibit. It is a filing that was been made on behalf of the county clerk. And what you're alluding to for the record is the certification of Deputy County Clerk Deborah Braga submitted on the clerk's behalf by Deputy County Counsel Ms. Athanasopoulos, and attached as Exhibit A to that is the reference to the statewide voter registration list for the voters implicated in the petition here. And that is part of the motion record.
Judge, if I may?
You may.
So if I'm looking at the Court Exhibit 2, there's the 4-3 ward box. Essentially the bottom right box of 4-3, that starts Cymbeline Avenue and would continue, I guess, in the southerly direction and hit the letter N in Press Mill Road. So essentially, we're talking.
Oh, I see, yes.
So
Okay,
that-
so that would be that red line there.
Correct, so.
That red line from under the box, the bottom right corner of box 4-3,
Correct.
that would be Cymbeline Avenue running from your left to right down to the M in Preston Mill Road.
That is correct.
Okay, got it. Got it.
And Your Honor, not to belabor the point, but again, when I read the map, I don't necessarily agree with counsel that this shows, certainly as not a disputed issue of fact, that this shows that the even number of residents of Cymbeline Avenue should have been, or properly in Ward 4. And certainly, I had asked that while I believe our motion, for the reasons stated previously and argued in our brief, that we're entitled to a motion for summary judgment. In the event Your Honor denies it, we would ask the same for petitioner's motion for summary judgment. Particularly, Judge, again, on the evidence, the record evidence that's before the court. So for example, Judge, if I'm looking at Oakland Road, which starts in yellow and continues to its intersection with Cymbeline Avenue, are the Oakland Road registered voters, are they all in Ward 2? Are they all in Ward 4? I believe there are disputed issues of fact in how you interpret this map. And again, I don't believe it stands for the proposition counsel is claiming. And again, for that reason, I would ask that in the event Your Honor denies our cross motion for summary judgment, the same be applied to petitioner's motion for summary judgment. Thank you, Judge.
Hold on, Mr. Howe. I want to hear from the Attorney General, and then Ms. Athanasopoulos.
Your Honor, the Middlesex County Board of Elections takes no position on Petitioner Rizzoli's motion for summary judgment, and they do not take position on respondent Joe Carroll's cross motion.
Okay, I just had one question for you, counsel. And
Yes.
while the count 2 of the petition, the amended petition, has been voluntarily dismissed, it's just informational for my purpose, because to be honest with everyone, it was a little startling to the court to realize the pervasive issue that arose on election day. And as the election judge here in Middlesex, I was privy to statewide loss of Wi-Fi connectivity to the new electronic books in many other counties, which I say was startling because this was all rolled out as part of the Early Voting Rights Act for this election. It doesn't appear that any of these systems, the new electronic poll books or the machines used, have been tested or pilot programmed. And as a consequence, at least the allegation in this petition that has since been dismissed, but it alleged that emergency ballots were used by poll workers in this election when they should have used provisional ballots. And the reason was because in using the emergency ballots, there was no way for the poll workers to verify the registration status of a voter because the electronic poll book was down. And I believe in your brief you indicated that provisional ballots would be necessary to utilize because that would allow someone who was standing online waiting to vote, who couldn't wait any longer because the system was down and malfunctioned, to at least complete a ballot and thereafter submit it to the Board of Elections to undertake through its staff to verify the registration status in order to determine whether the vote would be canvassed and counted. Is my understanding correct?
The Board of Elections obviously would be able to further explain the specifics of that. I mean, I couldn't testify on behalf of a client, at least at this point, since we're not having a trial today. I could tell you that as the court knows, there were system-wide problems with the poll books, that the emergency ballots that were used were put into provisional ballot certificates, and the board made an accounting for that. But that's just to, tell Your Honor, generally speaking, of what had occurred. And if the court needs additional information prior to ruling on the motions, I can speak with the board and we can submit something.
Well, I guess, and I know I'm just digressing, I'm off the rail a little bit here, but if anything, this election contest action before the court has raised an implication, an issue that I think for future elections and the benefit, given the fact that there was that unforeseen, or maybe it was foreseeable, but certainly the unforeseen loss of Wi-Fi connections to those electronic poll books, that there should be better or improved instructions given to poll workers, because there are, as I understand it, from this Athanasopoulos, that there are elections forthcoming in January for the fire district, as I recall, and thereafter in February again. So, in any event, I apologize and pause to note that, but it's only because of election contests where it appears sometimes there are flaws that no one detected that have been uncovered, and now becomes necessary to redress them because this court is, as it's entrusted with the obligation to do, is to ensure that the integrity of the electoral process isn't undermined, so that these kinds of issues can be prevented. But like I say, that's just anecdotal on this side, and I had that question for you since you were here. Okay, but thank you. I understand your position.
Yes, they were decisions that had to be made in real time, and the overarching goal was not to disenfranchise voters. And given the widespread problems with the Wi-Fi, there were decisions that were made on the fly just so they didn't have to turn voters away from the polls. But
right, but there appeared to have been some instances where provisional ballots were being used, and then emergency ballots were being given and used, which itself creates an issue. But lessons learned.
Again, without the benefit of having testimony, but the actual materials were running out, so they were forced to use forms, but they were put in provisional ballot certificates.
And those machines do not have a on-site or in situ pre-printing generation feature.
Correct.
So these would be what the statute requires, the pre-printed provisional ballots and the pre-printed emergency ballots. Right, and had to be utilized. Okay,
Yes.
thank you. Thank you for that clarification. Ms. Athanasopoulos.
Thank you, Your Honor. The Middlesex County Clerk does not take a specific position regarding the pending instant applications that have been filed by Petitioner Rizzoli or by Respondent DeCaro.
I do have a question for you, though, because of Exhibit A attached to Ms. Brady's certification.
Yes.
And the court had a benefit of reviewing it in connection with the briefs and so on. And there is at least, and perhaps you could help reconcile the discrepancy that's been addressed by Mr. Howe. There were 17, and by my count, 17 registered voters who arguably had legal votes rejected because they should have been voting in the 4th ward and not the 2nd ward. And there's apparently, help me with the calculation, there's not 17 but 14. Can you reconcile it for me?
If I can just for this court's edification. So the SVRS printout marked as Exhibit A reflects that there are 27 active registered voters and not 33. The difference of the 6 voters is depicted on Exhibit A, and those 6 voters are deleted for one reason or another. Either
Right.
they have passed away, moved, or whatever the case may be. So now we are left with 27 active registered voters. Of the 27 voters, 13 voters on the even side of Cymbeline Drive are registered to receive mail-in ballots. Those 13 voters were in fact mailed the mail-in ballots. Of the 13 voters who were mailed the mail-in ballots, 8 ballots were returned to the Board of Elections.
One of which was rejected.
One of which was rejected
Right.
because there was no ballot in the actual envelope. So there were 8 ballots returned to the Board of Elections, 7 were counted.
And arguably, it would have been the same ballot that at least the petitioner argues would have been wrong.
Perhaps.
Okay, okay. I'm just trying to understand the
Yes.
chart. Okay, got it. I understand that. And then of the, at least as I count, of 17, of the 17, 9 of them were machine votes.
Yes, and then 14 of the remaining registered voters on the even side of Cymbeline, 9 of those voters actually cast their ballot on a voting machine, 2 of which did so during early voting.
Right. Okay, I understand.
Okay?
Thank you very much.
Absolutely.
Okay. Yes, Mr. Hammond.
So maybe I misquoted or misread the certification with my $3 glasses on. It does appear that there were 17, it does appear that Exhibit A to the deputy clerk's certification does support 17 votes. I just went back and scrolled through the list of even numbered voters. So either way, the number exceeds. But going back to the one...
So just to follow on, since we're looking at Exhibit A, and to be clear, let the record reflect this, the SVRS printout. Geraldine Halpern voted by mail. Henry Halpern at 4 Cymbeline Drive voted by mail. Jeanette Crespo Lee, 10 Cymbeline, voted by mail. Emil Lee, 10 Cymbeline Avenue, voted by mail. Kyung Ki Lee, who was also at 10 Cymbeline Drive, was the one whose mail-in ballot was rejected. Lawrence Lee at 10 Cymbeline voted by mail. Daniel Tucci at 14 Cymbeline Drive is not applicable. And as the legend defines it, it didn't receive a mail-in ballot and didn't vote in the election. But nonetheless, 14 Cymbeline Drive, Michael Tucci voted by machine. 14 Cymbeline Drive, Patricia Tucci voted by machine. Those at 20 Cymbeline Drive are crossed out with deleted voters. They didn't vote for one reason or the other, as council indicated. They may have passed away or moved. But nonetheless, 20 Cymbeline Drive, Linda Minor voted by mail. Jeffrey Lures at 20 Cymbeline Drive voted by mail. Arthur Chapman at 30 Cymbeline Avenue voted by machine. Ronnie Chapman at 30 Cymbeline Drive voted by machine. Dorothy Shaffron at 36 Cymbeline Drive voted by machine, was an early voter. Joseph Shaffron at 36 Cymbeline Drive voted by machine as an early voter. Stuart Shaffron at 36 Cymbeline Drive voted by machine. Emmanuel Paco at 38 Cymbeline Drive voted by machine. And Maria Paco at 38 Cymbeline Drive voted by machine. Now, by my count, those individuals who have been identified as voters is 17. Yes.
So
And also, just so it's clear, the last two entries showed deleted voters, but there was one voter, Milagros Burgess, who, the legend bears, didn't receive a mail-in ballot or didn't vote, but nonetheless was at 26 Cymbeline Drive, but reflected as being in Ward 4, District 3.
in addition, from the certification, I just to address, although
Hold on.
you didn't call me.
Hold
did you?
on, but no,
Sorry.
I want to ask the question, and this is for you and Ms. Thanasopoulos. So to take the petitioner's argument to its conclusion then, all of those 17 that I've alluded to should have been as Burgess Milagros, who was also an even numbered in Cymbeline Drive, reflected in District 4, or I should say Ward 4, District 3, not District 2, Ward 4.
I can speak to that, Your Honor. However, it was not part of the certification because that was not a matter of an issue. And perhaps, should this matter proceed whereby testimony would be required, the Deputy County Clerk would certainly be able to testify to that fact. But I can tell you factually that regarding Ms. Milagros Burgos, she submitted a registration to vote after the integration of the new SVRS system. So all of this information pertaining to these voters was in the former system, the legacy system, and that was all then integrated into the new SVRS system.
When did the new SVRS system
I believe it was,
accomplish the integration?
was it 2019? I believe it was 2019. And the reason why, like I said, Ms. Milagros Burgos appears in District 4, Ward 3 is because she registered to vote after the fact.
But nonetheless, an even numbered house on Cymbeline Avenue, Cymbeline Drive.
Correct. And again, my deputy county clerk, should her testimony be required, would certainly testify to that fact.
Okay. Thank you.
You're welcome.
Okay, Mr. Howe, sorry I interrupted.
No, and I apologize for jumping to some, a long time something will happen in person. So as far as, I don't think I need to reiterate what I've said. Paragraph 11 of the Deputy County Clerk certification indicates that the county clerk doesn't have the authority, and I think we could probably come up with hypotheses as to why the office that sends out the ballots shouldn't be able to change something like that.
Well, but because the wards are established under the municipal ward law,
So,
by the ward commission.
and so but that doesn't mean that someone else might not be responsible. I could have hypotheses about who else has the ability to make that entry. I don't know for sure, but it could be the Middlesex County Board of Elections. It could be the division. I go on high because I get to the higher level of government down in Trenton, the State Division of Elections. Someone, somewhere, made the mistake wasn't the county clerk's office. So I think that the distinction, I addressed what I thought the distinctions were, I anticipated from the Parker case. It doesn't matter that 2020 was an all vote by mail election. It doesn't matter that in that case the county clerk made a pretty glaring mistake that resulted in his early retirement. In this case, it's not the same thing. Despite headlines on the internet, it's not the same thing. It doesn't matter. The mistake was made within the system. The voters didn't make the mistake. They could have voted in the 4th ward. Should have been voting in the 4th ward. If we have to go to, it's always a clue to me when someone says, on this record. Well, the reality of it is, on this record there is enough. If we have to go to trial, there will be more than enough. I could envision a couple people getting called, maps getting blown up, maybe a resolution from the Board of Elections from 2010, but there's enough on this record.
Anything further?
Nothing further, Your Honor.
Okay. First of all, I want to extend my compliments to Mr. Howe, Mr. Antonelli, Ms. Allen, and Ms. Athanasopoulos for, first of all, your collective professionalism and the high caliber of the legal work that has been performed in very tight timelines and deadlines. It's very clear to the court that I have the benefit of experienced counsel in this area. Not that that makes my job easier, but it does in the time constraints that we are. I'm very sensitive to the importance of this issue to the parties, but given that we are, as the statute provides, in a limited window in which this proceeding had to be scheduled and conducted and accelerated discovery accomplished, is very much appreciated by me and this court on behalf of certainly the candidates, the petitioner and respondent, and the voters in Old Bridge Township, which heightens the seriousness with which I always take matters, especially in this particular matter as well. I am going to reserve my decision on the motions for summary judgment. I want to think about things based upon the argument that has been raised here today and the responses to questions that I've posed. But I will render a decision before the year's end, one way or the other, and the parties will have the benefit of a written opinion in that regard. It's interesting how our election laws are established. Contests, you can't schedule a trial later than 30 days from when the petition is filed, and you can't schedule it any sooner than 15 days. And therefore, there's that 2-week window in the middle that happens to fall over the holidays. And I know that's been an inconvenience to all the parties. And I'm not going to complain because that's my job here as a judge of the Superior Court, nonetheless. But that's not going to take away from the seriousness with which I treat these issues, and out of respect for counsel and your respective clients, get the benefit of a written opinion in advance. I'd like to accomplish it before the reorganization meeting, one way or the other, so at least the parties have direction. And I did indicate, and again, the record reflects our discussions on our status conference on Monday, that if and as I determined the trial was necessary, that at least you have an outer marker as to when I will accommodate and schedule them, which would be not that long after the reorganization meeting. So, Mr. Carroll, if it becomes necessary, you wouldn't have to take office, not wait 6 months or a year, if that becomes the case, but we'll address it at that time as need be. So at least you have some knowledge and some certitude as to the timeline going forward, and that you can enjoy the holidays and not think about this case until my decision is issued. So with that said, unless there's anything further, council, I do appreciate the efforts made to narrow the issues. Once again, these matters come before me, they're always interesting, and in these pandemic times and having to wrestle with no less than 4 major changes in the election laws over the last 3 election cycles and more to come, it kind of amazes me that we don't have any more issues come about. But then again, it does amaze me that flaws that may have existed haven't been uncovered unless and until there's been a contest raised, there's an issue raised. But nonetheless, that's why we have the procedure. So with all that said, unless there's anything further, I'm going to adjourn, reserve decision, and most importantly, I want to extend my best wishes to each of you and your families, continued good health and safety. I appreciate you accommodating my directive that this be conducted in person today with our COVID-19 safeguards, because that's important. And I also want to extend to all of you happy holidays and the best for the new year around the corner. All right?
Thank you. Thank you.
Thank you.
And your family as well.
Thank you as well.
Thank you.
Okay.
Thank
Very
you.
welcome. We'll see you
Thank
at the
you.